advisors to their neighbourhoods, close places of worship, accused of conditioning terror, and carry out more on-the-spot identity checks, all without the prior approval of a judge. Well, we can talk now to one of those officials, Fionnuala NI AOLAIN, UN expert on the promotion and protection of human rights and fundamental freedoms while countering terrorism. Thanks very much for being with us on the programme. I mean, some people might say that France has been in very special circumstances here. We've obviously had a series of jihadist attacks over several years. What else could it do but seriously increase measures designed to try and stop or at least reduce the number of attacks here?
Sure. There's absolutely no doubt that France, like many other countries, is facing really severe and difficult challenges from terrorism, from violent extremism. There's no doubt that that stretches the ability and the traditional capacities of any state. I think the challenge, however, is understanding, first of all, whether these powers will be effective. And there is real doubt by many experts, including myself, whether the permanent institutionalization of emergencies, in fact, ultimately leads to less violence, or in fact can, in some sense, ratchet up the cycle of violence and the conditions conducive to the production of violence. So that's one very questionable, I think, basis for such measures. And the second is really, I think, often when there's a time of crisis, when awful and compelling violence takes place, the response of the state is often instinctive. The instinctive response is simply to pass more law, because that serves a sort of a reassurance function for the state that the state is doing something. But often that is done without fully testing whether the ordinary criminal law is capable of, in fact, dealing with the challenges posed to it, or whether or not, even with small adjustments, the state is capable. France is a leading democracy. It has a robust, incredibly robust and effective judicial system. It is better placed than most countries in the world, in fact, to test and to be in the position to demonstrate that the normal legal system can cope and can cope well.
But it hasn't coped well, though, has it? Because surely if it was coping, it would have managed to stop some of the attacks. I don't know if you heard me there. I was saying the problem is, of course, that it hasn't worked.
I think we have to be careful of drawing those kind of lines that says more laws. I'm not sure. Certainly, there's no doubt that every country, including France, faces extreme threat. But to assume that the work is done simply by more exceptional powers, I think, is in itself a line drawing that hasn't been proven to work well. For example, we've seen countries that have institutionalized states of emergency for decades. It hasn't, in fact, over time demonstrated that it more effectively deals with terrorism. So the cause and effect here is ill-proven in terms of both the body of legal norms as well as the kind of data available to us that shows whether or not these laws are effective to do what the state says they do.
So do you think it would be better then just simply to leave things as they are, actually, in a way, do nothing and just carry on with the systems already in place?
No, I don't think the answer is to do nothing. I think states have an obligation to protect their citizens, and security and safety is also a human right under international law. I think that's a clear understanding. I think the challenge here is to say whether or not one should simply, in fact, abandon some of the most core elements of due process and rights protection that are fundamental to the functioning of the legal system in response to what is clearly a challenge for the French legal society and for the French political system. And in particular, my concerns, as addressed in the communications to the French government from the United Nations, are first of all the abandonment of the engagement of the judicial power, particularly in the power given to prefects to designate, as you've noted, public spaces, limiting people who can enter and leave. There's no reason to believe that France and French judges are incapable or not well equipped to do that job. But to abandon the right of judges to engage in that kind of judicious intervention in a functional democracy, I think, is an abdication, not just for France, but is an abdication, a potential abdication of the rule of law that does not serve France well in the long term.
We'll have to leave it there. Thank you very much for talking to us on the programme. That's Fionnuala NI AOLAIN. Apologies as well for the delay on the line there, but good to get your views. Now, they